Well, friends, do you know what is common between Anthony Alphonse, BL Gupta Construction, KL Trading Corporation, and SAS Fininvest LLP? Well, all these are the names of the assessees who have recently filed their respective writ petitions before the respective honorable high courts against their regular assessment orders for the assessment year 1819 passed under the new faceless assessment scheme. And the respondent in all these writ petitions is common, that is National E-Assessment Center. And the ground which has been taken by all these petitioners is also common, that is the impugned assessment orders have been passed against the principle of natural justice without affording the suitable opportunity of being heard to the assessee. While in the case of Anthony Alphonse, the Honorable Madras High Court has quashed the impugned assessment order on 7th May 2021 on the ground that the assessment order had been passed even before the time period which was allotted to the assessee to file his reply. And in other three cases, the Honorable Delhi High Court have granted an interim stay against the operation of the respective assessment orders on the ground that the final assessment orders had been passed without issuing the mandatory show cause notice to the assessees. Well, friends, all these recent developments again brings us to the core issue, that is the doctrine of audi alteram partem, that is here the other side, and its application in the new faceless regime. I am Mayank Mohanka, founder director in Taxaram India Private Limited, partner in SM Mohanka and Associates, and an author with Taxman Publications. Friends, for the assessment year 1819, the time barring completion period has been extended till 30th June 2021 in view of the ongoing corona pandemic. However, majority of the cases have been concluded, and in almost 80% of the cases, the returned income have been accepted by the department authorities. But only in those cases where this doctrine of audi alteram partem could have been really tested as to whether the suitable opportunity of being heard is being fully adhered to in this new faceless regime. That is the cases where deviations had been proposed by the regional faceless assessment units to the returned income. So it was only in those cases where this principle of audi alteram partem could have been tested. But unfortunately, like these four cases, it was only in those cases even the mandated prescribed conditions in the faceless assessment scheme, that is the issue of the show cause notice, passing of the draft assessment order, was somehow not been complied with. Friends, I have always been very vocal about the necessity for granting of an adequate opportunity of being heard through video telephony or audio conferencing as a matter of by default right to each and every SSC if he so or if he so desires. In the initial scheme, this by default right was very much there, but somehow in the subsequent schemes and now in the newly inserted section 144B, which has been made functional with effect from 1st of April 2021 in the Income Tax Act, this by default right of personal hearing through either through video telephony or through audio conferencing is not there. And it is only in selective cases the assessee can only request for grant of this opportunity, and it is totally up to the discretion of the regional director or the chief commissioner or the director general of the regional faceless assessment center to grant this opportunity of personal hearing through video telephony to the assessee if the circumstances uh, fall in the categories, specified categories to be notified by the CBDT. But till date, these circumstances have not been notified. And for the assessment year 1819, only a very handful of cases have been selected wherein the VC or the video conferencing facility was being given to the assessees. But even in these cases also, the final assessment orders had been passed without even the elapse of the time of the video conferencing uh, facility to the assessees. It appears that this being the first year of this full-fledged faceless assessment regime implementation, and more because of this unkind and unthinkable misery caused due to this unprecedented corona pandemic, even the implementing authorities, that is the regional faceless assessment centers and the nodal authorities in the national assessment e-assessment center, are somehow finding it little bit difficult to strictly adhere to the mandated prescribed procedures. That is the passing of the draft assessment order, then assigning that draft assessment order to another review unit, then further to another review unit, another assessment unit other than the original assessment unit which has passed the order. It appears that this lengthy process has not been followed in this first season of faceless assessments due to the paucity of time, or either due to the lack of awareness or training to the concerned implementing authorities. In addition to this, in faceless appeals also, the faceless appeal orders, the faceless appeal scheme has been introduced with effect from 25th of September 2020, and almost all the assessees have received the faceless appeal notices also almost 3 to 4 months back. But till date, not even a single order of faceless appeals has been churned out of this new scheme. This probably may be on account of this Vivad Se Vishwas settlement window. But nonetheless, in my humble understanding and opinion, faceless appeal orders should be should come, the faceless appeal orders and the adjudication of appeals should start, so as to give us a fair idea as to what kind of orders are being churned out, how the authorities and appellate authorities are responding in this new faceless regime. So uh, early disposal of the appeals is the hallmark of the success of this faceless regime. So timely and judicious disposal of appeals should be adhered to, and faceless penalty scheme has just started. The announcement has been made on 12th of January 2021. The scheme has been launched. So let's see what is in this scheme for all of us. And I hope that this landmark and pioneering tax reforms of faceless adjudication do reap us the desired and expected benefits. And in order to fully reap the benefits of this faceless regime, it is but essential for all the stakeholders, not only the assessees, but also the implementing authorities, the assessing authorities, the regional faceless assessment units, the nodal agency, the National E-Assessment Center, should also embrace this new tax reform with open minds, and at least the mandated prescribed procedures and safeguards should be strictly adhered to, so that the situation which has come up in these four cases, at least those situations should not arise, because obviously those cause undue hardship to the assessees, and first impression is the last impression. So all the hard work and deliberate drafting and meticulous drafting and efforts should not be allowed to go in vain just because of some carelessness on on the part of some authorities. Friends, I would also like to share that my new book, Faceless Assessments, Appeals and Penalties Ready Reckoner with Real-Time Case Studies with Taxman Publications, is out there, and it is available in all leading bookstores and online and Taxman and Amazon. Obviously, in these taxing times, it is not at all advisable to step outside your homes. So, but nonetheless, my book can step inside your homes. You just need to place an online order in Taxman or Amazon. Taxman is offering 15% discount also, and they are strictly adhering to all the safety norms while delivering these books at your doorsteps. Uh, Signing off. with a humble request. Do keep safe and immune yourself from this deadly virus. Okay, bye bye. Take care.